Bonjour à toutes et à tous. Hello, everyone. Welcome to the virtual edition of We Robot 2020, the premier international conference on law and policy relating to robotics, hosted this year by the University of Ottawa Centre for Law, Technology and Society. Reinvented in the times of COVID-19, We Robot 2020 is presented with the generous support of Microsoft, CIFAR, X, and Intel, as well as the University of Ottawa, the University of Washington Technology Policy Lab, and Miami Law. Now, for those of you who are not familiar with the We Robot format, please note that authors do not present their own work. Instead, session discussants read the author's papers in advance of the conference and then present the author's work to the audience, while offering constructive thoughts for improvement and seeding the discussion that follows. Authors will then have 5 minutes to respond to discussants' feedback, and the session will open up to the floor. For the virtual edition, we invite the audience to engage with the papers in the comment section below the video. So for today's session, we are just delighted to welcome as our discussant Jennifer Razzo from the University of Alberta, and she will present Administrative Law and the Governance of Automated Decision-Making, a critical look at Canada's Directive on Automated Decision-Making, a paper by Teresa Scazza from the University of Ottawa. A link to this paper is available underneath the video. So without any further ado, I'll turn it over to you, Jennifer, and look forward to hearing your comments on this fascinating piece.
Wonderful. Thanks so much, and thanks for having me. I've been a fan of the We Robot event, but have never participated before, so I'm very delighted today to be engaged in this virtual discussion of Professor Scazza's paper. So what I'll do is I'll trace two main arguments that I see being advanced in this paper. The first is one that is explicit, and the second one that seems to be a bit more implicit in the paper itself. And as I go along, I'll raise some questions and comments about these arguments and how they fit within the landscape of Canadian administrative law. So in Professor Scazza's paper, she traces the genesis of this directive, so the Canadian Federal Directive on Automated Decision-Making and its partner tool, the Algorithmic Impact Assessment. And she includes very interesting detail about the consultations that led up to the creation of these two linked policy devices. And she notes that the directive is a unique internal governance mechanism that's been created at the federal level in Canada to ensure that particular standards are met when federal departments plan to introduce automated decision-making into their operations. So looking at the directive and the first argument, I would identify as being the explicit one, which is that this directive is more or less guided by administrative law principles. And specifically, the paper focuses on a series of principles that can be linked to the notion of fair process in Canadian administrative law. But at the same time, Professor Scazza notes as she works through these principles that some appear more or less in different types of forms, and that the directive seems to introduce new notions of what fair process might mean in the way that it identifies and sets certain standards that are linked to these principles. So the fact that this directive takes an administrative law approach, or that administrative law principles are identifiable within its text, is something that's unique about this directive. So by comparison with the European GDPR, which takes more of a data protection and privacy lens to the issue of automated decision-making, this directive really does center on the notion of what a fair process might mean, albeit this notion is unique, I think, to the directive when we read it against administrative law principles. And so although the directive has some shortcomings, so for instance, it might be a bit tricky to identify specifically which decisions the directive governs. Although it excludes certain types of decision-making, so automated decision-making tools that already exist will not be subject to the directive's requirements, and also that very potentially wide national security exemption means that any automated decision-making system that is identifiable as a national security system would not be subject to the directive's requirements. Despite those two potential gaps in the directive's coverage, Professor Scassa argues that ultimately the directive is this unique and potentially quite useful governance tool in Canada and potentially in the world when it comes to the types of policies and other types of tools that governments have introduced to regulate automated decision making. I won't get into the details of automated decision making versus AI versus machine learning. I expect that the audience at this event is very well versed in those details. So what I will focus on here is the administrative law component of the paper. So there are two points from an administrative law perspective that I think are quite interesting about this argument that there is an administrative law lens that's being taken in the directive. First is that the directive is noted to have potentially quite significant impact, and that this impact may already be felt on the ground. So in administrative law, soft law tools are often identified as being less than what might be provided by a court in judicial review. And the directive, of course, is a soft law instrument. But Professor Scassa notes very well that this directive seems like it might already be having an impact on the ground when it comes to third-party vendors and the way that they're going about developing automated decision-making technologies. And so there is potential for this directive and the standards that it sets to really create a new landscape in terms of the functioning of automated decision-making tools. And I don't think administrative lawyers should overlook the importance of that impact. And the second point that is interesting from an administrative law perspective is the unique systemic focus of this directive that Professor Scassa identifies at various points throughout the paper. So administrative law, as she notes, tends to center its analysis and remedies at the level of individuals. So individuals are owed particular duties by state actors. Individuals are the ones that seek recourse through judicial review, primarily in Canadian administrative law terms. But the directive's requirements, some of them at least, seem to pinpoint accountability at a systemic level and conduct analysis according to systemic harms or biases that automated decision-making might lead to. And so we see this at the level of bias, for example, and the way that the algorithmic assessment or impact tool, the algorithmic audit tool that those particular pieces of the directive seem to be targeted at identifying systemic problems and tackling those systemic problems. And that's quite unique from an administrative law perspective. So looking at the rest of the argument that this directive does center on and reveal an administrative law approach to automated decision making. The focus of this paper, as I've noted already, is on the procedural fairness components of the directive. And Professor Scassa identifies three types of principles, or three, we could think of them as categories of procedural principles that are evident in this directive. The first focuses on decision makers, and so the directive does center on decision makers to some extent, but Professor Scassa notes that here the focus is on systemic bias and potential for systemic issues to impact the quality of administrative decision making. And so this is distinct from what administrative law would focus on when it comes to decision makers, specifically that a decision maker should be legally empowered to make a decision, then relatively open-minded and independent. And so Professor Scassa notes that while these systemic components of the directive are valuable and unique to the directive, as distinct from what administrative law might provide, that when it comes to these more basic guarantees that administrative law provides, when it comes to decision makers and their qualities, that those appear to be perhaps absent in the directive or not easily teased out. When it comes to the second type of procedural guarantee, one that focuses on process itself, here the directive seems to provide some types of what in Canada we call participatory rights for individuals who might be impacted by automated decision making. But the directive, in my view, may not meet Canadian administrative law requirements based on Professor Scassa's articulation of how the directive and the algorithmic impact assessment function. So, for example, with the notice requirement, as Professor Scassa notes, when it comes to publishing on websites or other locations that automated decision making might be used in a particular context, that might not meet the important notice requirement that administrative law requires in most settings, which is that individuals should know the general gist of the case that they have to meet. And so notice in administrative law sometimes combines disclosure a little bit, in the sense that my read of notice, at least, is that it requires that decision makers allow and ensure that those who will be impacted by their decisions have a general sense of the standard that they need to meet, the evidence that they might need to introduce, and how their evidence might be read. And in addition, there's some requirements that individuals be provided with a sense of what evidence the government has on the other side. And it's unclear to me whether this notice requirement is at all met in the directive. Certainly, it seems that the directive's requirement that the notice be given on websites that automated decision making will be used, kind of writ large, is something that seems to fall short of this requirement. When it comes to hearing as well, another type of procedural guarantee, Professor Scassa usefully notes that the human in the loop approach that's taken by the directive might not be sufficient. So while administrative law doesn't necessarily require that an individual have a face-to-face hearing with a human being, it certainly does require that somebody or something hear, receive, and respond to somebody's evidence, their arguments, and so on. And it may be, as Professor Scassa notes, that there's something intrinsic to the concept of a hearing that requires an actual human being to hear and to weigh arguments that are being made by individuals who will be impacted by a decision. So here, the human in the loop requirement is inserted by the directive, borrowed from other contexts, but that might not be sufficient for administrative law purposes. And then when it comes to outcomes, so a third type of procedural fairness requirement, Professor Scassa notes that there's a right to a meaningful explanation that's been adopted into the directive, borrowed from elsewhere, and that this applies for some limited decisions. And this right to an explanation, in my view, seems to be quite a new thing for administrative law, in the sense that it's quite distinct from the reasons requirement that administrative lawyers across Canada will be familiar with, and which seems to be an even more important requirement today, given the focus on reasons in substantive review that we see in the Vavilov decision, an influential decision recently released by the Supreme Court of Canada. And so whilst Professor Scassa notes that this right to an explanation might harken some kind of new standard for administrative law in Canada, one burning question that I have about the directive itself and its potential impact is what happens to the value of reasons requirement in administrative law in Canada. And some may say that the reasons requirement's already suspect or potentially threatened by the Vavilov decision, which unfortunately I don't have enough time to get into in detail, but certainly many Canadian administrative lawyers would argue that the need for administrative decisions to be justified through reasons, not just explained, but actually justified in terms of why they're legal, why the way that the state exercises authority and power in a particular setting is in accordance with law, that's distinct from the right to receive an explanation as to how a decision was reached. And Professor Scassa notes that there is this distinction. She references Jennifer Cobb's work from the UK that identifies this distinction, but I would suggest that there's more to be unpacked here from a Canadian administrative law point of view. So with the implicit argument, and I realize that I'm running quite short on time, this is the problem when you have such a rich paper to discuss as a discussant. I would just highlight that the second implicit argument that I noted at the start is that this directive and automated decision-making are the territory of administrative law. And so this is perhaps a controversial point for administrative lawyers in Canada. That is that administrative law has a role to play in the governance of automated decision-making, whether or not automated decisions end up being the subject of judicial review. And as I've alluded to in my comments, Canadian administrative law tends to focus on the judicially reviewable decision and focus on what happens when courts do judicially review a decision. What do courts say? That's certainly the basis on which we glean the principles of administrative law. However, when it comes to automated decision-making, very often automated decision-making tools are introduced into what Virginia Eubanks calls low rights environments. And while they might have potentially wide scope for impact and significant impact on individuals, it's very rare that they will ever be judicially reviewed. Nonetheless, this is an area where administrative law needs to play a proactive role, and administrative lawyers need to play a proactive role in terms of reconceiving what administrative law might mean in this context. And so with that in mind, I would just leave us with this question, which is what is the role for administrative law in this space, and what does administrative law mean here? Is it distinct from fairness, accountability, and transparency, which seem to be the language that's adopted in the directive and language that has begun to dominate in the sphere of automated decision-making? It appears to me that administrative law and the notion of the rule of law might require a bit more than just fairness, accountability, and transparency. And so here I'm thinking of that reasons requirement in the work of David Deisenhouse, which centers on justification, as well as the notion of contestability that Mira Hildebrandt has advanced in her work, and the need for contestability to be built into automated decision-making systems at the first instance, rather than being something that's left to judicial review. So perhaps we can delve into some of that conversation in the discussion. I know I've gone well over time, my apologies, but I look forward to hearing Professor Scassa's thoughts. Thank you.
Thank you so much, Professor Razzo, for that. I'm thrilled to have you as the discussant for the paper, and I really appreciate your thoughtful comments and feedback. Just to explain a bit, back in a long time ago, I used to teach administrative law, and I loved administrative law. And so there was a period of time when I was quite immersed in administrative law, but then my career kind of kept dragging me further and further into law and technology subjects. And it's been a long time. And it really was just a year and a half ago, or a couple of years, it's a little bit of a blur, when I started looking at the directive on automated decision making, having seen a lot of discussion about automated decision making in the privacy context. I was looking at the directive on automated decision making, and to me, just the administrative law aspects of it jumped out at me, and I thought, well, this really deserves a little bit more attention, which was part of the genesis of the paper. So I do find it really interesting that that one of the things that you pulled out of this is the relationship of the directive with respect to administrative law, because I do find it interesting that for the most part, and I think this is the influence of the GDPR, frankly, but I think for the most part, people have been focusing on automated decision-making through this privacy lens and looking at reforms to privacy laws and what needs to be added to sort of govern how data is used in decision-making. And as a result, there's been relatively little attention, I wouldn't say none, but relatively little attention on the administrative law dimensions of automated decision-making. And I think that those are worth exploring. And I really like your comments also about soft law tools in administrative law. And I know this is something that you've written about, and I think it's really interesting as well. It's really taking a more pluralist approach to administrative law, and rather than sort of the approach that's tied to courts and institutions and tribunals and what they say and what they do, but looking at sort of pluralist approaches, not only what different types of instruments might play a role, and even things like procurement, which you've written about, which I think is fascinating as well, and the role that it can play in providing good governance with administrative systems. But I know you've also written about the informal roles of decision makers within administrative systems, and so I find that aspect of it quite fascinating as well. And so I think that your question about about what the role for administrative law in this space is and what it really means, I think that's a great question, and I think a very challenging one. And I think it would be, and to the extent that this can spark any sort of broader discussion about what the role is of administrative or of administrative law with respect to automated decision making, I think that would be a fine thing. I'm just going to have a quick look over my notes, because you raised a lot of comments, and I just want to make sure that yeah, you were talking about the reasons requirement and the value of the reasons requirement in administrative law, and I think that that's an interesting one as well. I mean, I think, I don't know, my thought when I was looking at this was the reasons requirement is already one that is heavily I don't think modified is the right word, but it's quite variable in administrative law. Certainly that's been my experience. So that in a sense, it takes this sliding scale approach that you see replicated in the directive, where decisions with much more importance have much more significant obligations, and decisions that will have lesser impact have less significant obligations. And so both the notice requirements and the reasons requirements in the directive, but I think also in administrative law, map onto that sort of sliding scale of significance. And so this becomes, I think, quite interesting in the context of the reasons requirement under the the directive on automated decision making, in part because in those contexts where you have both a human and machine involvement, which are going to be on the more serious or high impact end of things, because for the low impact, you don't even need a human involved. It's just decisions are churned out, and it's pretty pro forma. And you can imagine that the reasons in that context would be pretty pro forma as well. But on the higher end, where you have both the human and the machine involved, is where you're going to have the higher degree of impact, and therefore much more of an onus to have or a requirement to have reasons for the decision. And I think that the interaction between or human and machine with respect to the roles in that context is a really interesting one. You know, how does the human have to explain, for example, how they responded to a machine-generated risk factor or risk assessment in making their decision? Do they have to is all that they have to say, and I relied on this score as one of the factors in making the decision, or do they have to say I relied on this score and I know it's reliable because I've made the following inquiries, or because this is a system that has been, you know, it's not clear to me how those two roles get reconciled when it comes to the reasons for decision. So that's another point that I think is really interesting and deserves further exploration. In terms of the contestability, and you mentioned that towards the end in terms of the implicit argument, and I'm just going to throw out something else here, and this is something in part because I struggle with it as well. I talk about it a little bit in the paper, but I don't get into a lot of depth. I think there are a number of points in the paper where I kind of throw these things out. I don't know where to go with them, but the paper ultimately couldn't be 100 pages long, so that's for another day or for other people, better people than me. But contestability is one of them, right? And it's one of the things that I find interesting with this directive is that it creates its scale of impact and harm, and its sliding scale of impact and harm with different sliding obligations, but it does talk about harm in very broad terms, and it's harm not just to specific individuals, but also to communities, and to sort of a range, to possibly to the environment. And it's not clear to me whether those are kind of either ors depending on the nature of the decision, or whether it's actually acknowledging that automated decision-making as a practice can have harms that should be contestable by other than just an individual affected by the decision. And I don't know what the answer to that is, or maybe, no, I do. My answer would be yes. There should be some form of standing for individuals or communities that are harmed by automated decision-making in a more systemic sense, and not just individuals who are affected by particular decisions. And so it seems to me that may be something also, and you may have a better sense of this, that is a shift or different from administrative law. And I don't think it's clearly resolved in the context of the DADM, and in fact the DADM doesn't contain any enforceable rights in any event, so it's really a matter for the courts and their interpretation of administrative law principles to think about. But I do think this issue of who actually is affected by automated decision making is an interesting question in administrative law, that it might not just be specific individuals, but it could also be broader groups. So maybe I'll stop there and we can have more of a back and forth discussion. But
yeah, I think that contestability point, maybe I'll jump in there and then we can weave our way back through some of the other points, is one that is a challenging one. And I think that, so Mira Hildebrandt, I think her work focuses very much on the kind of individual contestability in the moment, which still is reflective of administrative law's preoccupation with that individual duties owed to them, and then their ability to challenge the things that are being done by the state to them. And the point that you raise about the potential, either the potential in the directive or the need for the potential to exist for broader communities to be able to challenge and contest when automated decision making is being introduced or being used in a way that has very significant impacts to them as a community, that is something that's not easily captured by administrative law principles as they exist today. One of the reasons is that we see in administrative law judges giving either short shrift or having encountered conceptual roadblocks when it comes to how to account for and value the, we can think of them as participatory rights of communities. For example, in the Inuit Tipirasat decision, where when it comes to the interests of the Inuit Tipirasat group representing Inuit in Canada's far north in a hearing over rate setting, that the court decides that taking those collective interests in mind in what might be understood to be a legislative type of decision when it comes to rate setting is something that courts cannot delve into in terms of looking at the mechanics of what was done and what types of participatory rights this group was given. And so they leave that for cabinet and cabinet representatives and the CRTC and whoever else to deal with and kind of take a hands-off approach. And because administrative law in Canada is so focused and captured by judicial review decisions, I think that perhaps administrative lawyers might need to overcome their own biases towards that way of thinking about what rights and interests have value, and really need to widen their imaginations when it comes to thinking through these problems and thinking through what contestability might require, particularly when we have automated decision-making tools being rolled out with wide impacts on a number of very easily identifiable communities. And I think that that's one thing that reading your paper and then reflecting on the content of the directive itself that left me with questions. So I appreciated your parsing of the directive and identifying which exact decisions might be covered by the directive. I think that there's more to be unpacked there, perhaps in a different paper, because of course this one can't be 100 pages. But it does seem that the directive allows for a lot of wiggle room, as does administrative law, of course. Administrative law has that sliding scale approach to what's required in any given case. But the directive, in the way that it identifies impact and harms, and the way that it places obligations based on those harms and impacts, and potentially allows for quite a lot of automated decision making, as long as the decision's not final or doesn't have a significant impact on an individual. These are the kinds of flexible requirements that in administrative law we also see allowing for a very minimal or no standards to be applied in contexts where individuals who are members of identifiable groups are being impacted every day by very small scale decisions, right? But when we look at the kind of collective impact of those decisions, both on the individuals who are members of these groups as well as the group as a whole, we can understand the fatigue that these people experience, and perhaps the oppression that they are experiencing when they're subject to whether it's automated decision making or a variety of other types of kind of micro decisions that might not be final decisions, but that nonetheless might be on the whole representative of a certain type of injustice that administrative law doesn't do a very good job of identifying and providing redress for. So here I'm thinking of, you know, what happens when we have automated decision-making rolled out in a number of different, let's say, federal programs that all end up treating whether it's Afro-Canadians or Indigenous peoples in Canada differently, and imposing either higher burdens on them or denying them in very small ways access to state benefits that other folks might not need to access or rely on, or alternatively that targets these groups for state surveillance, for over-policing, for example, or in the context of environmental impacts and Indigenous communities that continually erodes away Indigenous peoples in Canada's ability to exercise control over their traditional territories, to govern themselves with their own laws, etc. And it might not be that an automated decision-making tool does that thing, performs that type of action in an easily identifiable macro decision that is harmful enough to be on the kind of heavier end of the scale in the directives terms. And similarly in administrative law, it may be that these decisions are so small that administrative law as well, with its sliding scale for procedural fairness guarantees, also would not really be able to capture the impact of all of these tiny decisions. So I think that this is a big challenge for both the directive and for administrative law as well. And we see this challenge, you know, in the news regularly today when it comes to the issue of targeting different communities for policing in Canada, which is an administrative decision, right?
Yeah.
But
absolutely.
somehow falls outside of the scope of administrative law conversations. And I think that that's a real challenge for and perhaps a significant limitation on the possibilities that this directive might have in the future.
Yeah, I agree. I think that this is something that I also was struggling with, trying to understand just what the actual scope of application of the directive would be, because as you mentioned, there's some very significant exclusions. I hadn't really thought about what you've just mentioned, which is even within the sliding scale of impact, that if you've got lots of incremental impacts in different processes and different assessments, that the overall impact may be very high, but each individual one is such that the actual burden of the normative burden is actually quite low. And so that is another challenge that I hadn't thought of. And so that's really interesting. I'd also thought of things like, and I know that governments are already using algorithms in these ways, but fraud detection algorithms, for example, that are just looking for patterns in order to identify people who might be possibly engaged in fraudulent activity. Is that a decision within the meaning of the directive on automated decision making? Because if it's not, then that whole framework, including the, which is which really imposes certain restrictions in terms of design and adoption, and there has to be an algorithmic impact assessment, and there are all of these safeguards that are built into it. But if it doesn't qualify as a decision, then what's the, how does it get governed? And so it seems to me that there probably are a lot of very significant types of algorithm assisted, if not formal decision making, that goes on within government, but systems that are being used that do have impacts, even if they're not decisions within the administrative law sense, that are left ungoverned. And so one of the risks then, although I still think that where it applies, the DADM and the algorithmic impact assessment tool can be very useful. One of the risks, of course, is it may make it look as if there's a great system in place and everything's good, when in fact there's maybe a decent system in place for a certain category of decisions, and then the rest of it is just whatever.
Yeah, and I think jumping off of that point and returning to some of the points in the paper, I think that is one of the questions that I have about the directive itself and the motivation underlying the directive. So I do think that the points where you note that the directive actually might be doing something that's quite a bit more than what administrative law might do in the same circumstances are very useful. But I'm a bit more perhaps skeptical or hesitant about the value of the directive, not only because it seems like there are a lot of flexibilities and built into the directive, but also because of the twin objectives that the directive explicitly identifies, one of which is a type of risk management, and the other of which is a series of other types of objectives that seem to be at cross purposes. So those were, increasing efficiency, ensuring that decisions are made according to Canadian law very broadly, framed there, and et cetera, et cetera. I won't list them all off. But it does seem to me that this directive might be, or might have underlying kind of its foundation, this concept of risk management or controlling the risks, or trying to respond proactively to the potential risks of automated decision making. And I know that you referenced Danielle Keats-Citron and Frank Pasquale's work on scored society, but I, having read a lot about what's happened in the United Kingdom for a few decades now in terms of advances in public administration, client-centered approaches, et cetera, that there's a striking kind of similarity to the language that's used and perhaps the ideology underlying the directive and what seems to have occurred in the United Kingdom for a few decades now in terms of trying to identify risks, audit to ensure accountability. Like these are accountants' terms that have crept their way into public administration. And so I'm thinking of the work of Michael Power and others. Carol Harlow's another one who have identified this turn. And certainly it's not a new thing. Even the book in which David Deisenhouse's essay on the importance of reasons and justification, the book in which that essay is located is The Province of Administrative Law, I believe it's titled, edited by Michael Taggart. And that book, written in the late 1990s, was a response to this turn in the administrative state to risk management, public-private partnerships, et cetera. So I wonder, even though we're dealing with perhaps new and exciting automated decision-making technologies, I wonder how much of this approach that we see in the directive is something that has these deeper roots, if not in Canada. And I think the roots are there in Canada, but definitely extending across the pond to the UK. So I would put that out there as food for thought as well.
Yeah, that is really interesting. And I think you put that very well. I had started when I was looking at doing a little bit of the background on administrative law and the evolution of administrative law. It did seem to me that that the whole concept of automated decision making was a shift back towards a more formalist approach to administrative law, where public policy just disappears from it, right? The idea that you can have this, you can do it all by algorithms, and you can do it all very rationally and in a structured and organized way in order to generate decisions was much more formalist than the administrative law I grew up on was meant to be, and that this seems to be a kind of shift. I hadn't thought of it in terms of this kind of public management approach in the UK and how that may be reflected in it as well. So I do think that's really interesting, and I know I don't get into it anywhere near enough in the paper, or very little at all in the paper. It is really interesting, and it does. Yeah, I think it's. Yeah, that's a big question. And I think it's another reason to actually approach this through an administrative law lens rather than just a privacy lens, because the privacy lens puts the focus on individuals and their data. But the administrative law lens, on the one hand, there's all these rules and principles of administrative law, but above that, there's theories of administrative law and of the administrative state. And and I think that there are really important questions to be asked about the role of automated decision making, or how automated decision making fits within those theories of the administrative state, because it is actually a change in how we make decisions. And I know you've pointed out in your other scholarships that it may not be such a dramatic change as we might think, because there have been decision trees and other sort of paper-based ways of mapping out decisions and structuring decisions and so on. So it may be more of a continuum, but we are now getting to this point where I think there's serious interest in governments in shifting to much more automated decision making, or decision making supported by automation. And I think that that shouldn't be happening without looking at what does this mean in terms of fundamentally in terms of the principles of administrative law and the administrative state. What is this shift that we're encoding here?
Mm-hmm. Yeah, no, I agree. And I really liked how you tied in that legal formalist kind of underpinning, or the potential for legal formalism to appear in a new version or with a new face through the use of automated decision making, as compared to perhaps the more pluralist or policy-driven approach that we see advanced in administrative law in court decisions and then developed in administrative law scholarship over the past, I would say, probably 40, 50, 60 years at least. I wonder, though, if this new type of legal formalism is the same as the old legal formalism. And by that, I'm thinking of perhaps the quite different version of decision-making and scope of decision-making that is allowed or enabled by automated decision-making systems, as compared to perhaps the Diceian formalist notion, which wasn't just formalist, but also rooted in a very particular idea of the scope, the appropriate scope of state action and state authority. And by this, I mean that that old version of legal formalism was very much one where the state should be kept small. The administrative state should be kept small. Administrators were not to be trusted, and wherever they were exercising authority, we should ensure that courts are judicially reviewing those exercises of authority in order to ensure that administrative officials are kept in check. And underlying that legal formalist notion was, I think, a kind of small theory of the state, that the state should be kept small. There shouldn't be a bunch of administrative tribunals and other boards making decisions, that we should leave things up to the legislature and to the courts. And by contrast, I think when we see the rise of automated decision making, what it enables is actually massive expansion of state power into all kinds of different areas, because automated decision making has the potential to allow, hundreds of thousands of decisions to be made very quickly by crunching some numbers, comparing your data with that of, millions of other people, and coming up with some sort of outcome, whether it's related to benefits or whether it's related to identifying you as a target for increased surveillance and so on. And that seems to be quite a different vision of the state, even if it is a formalist approach to what it means to be governed by law, and perhaps a formalist vision of the flexibility or lack thereof that is present in written laws themselves. So I think that that's an interesting point as well. And I would, push against perhaps the old formalism.
And the world has changed tremendously since that time. But you could also see it as and I don't disagree with you. I'm not going to try and argue that it's exactly the same thing, because it's not. But I do think it's interesting that in part in both function and rhetoric, it does limit the, so you had the formalist state that was limiting the scope and power of the bureaucratic state of the administrative state, and that then subsequently expanded enormously. And so in some ways, automated decision making is shrinking that preserve, or not preserved, but shrinking that part of the administrative state, and encoding processes and decisions that were otherwise part of that. I'm maybe not explaining this really well. And so you see statements being made along the lines of, well, decision makers are biased anyway, and the algorithms will be less biased than the human decision makers. And so in a sense, it's kind of pulling stuff out of that administrative state and saying, now we're going to formalize and encode it, and it's all going to be done by machine, and it'll be fairer and more just, and it'll be faster and more efficient. And so those in some ways are very different. That's very different language, and I think reflecting some of these other different factors that you're talking about. But it's going to do all of these things, but it's also pulling it back from the specialized tribunals and boards and agencies and the people who've worked with clients face to face and all of this, other part of the administrative state. So I'm not saying that it's exactly the same, but I think it's interesting that it does shrink I don't know. I'm not sure what I'm saying, but there's something about it. It seems to me that both shrinks the administrative state and the scope of the administrative state, and also disses it at the same time as being less efficient, less, we're going to save money, we're going to be more efficient, we're going to be faster, and we're going to be less biased because we're going to get rid of those pesky humans who make arbitrary decisions. And I think you've written a really interesting paper about those pesky humans who make those decisions and how important their role is within that decision-making process.
Yeah, I think perhaps maybe what we've identified here is kind of contradictory outcomes of automated decision making, that it might at once instantiate a more formalist vision of law and the potential for law, and as well as shrink the workforce within the civil service, which I think is really one of the goals underlying efficiency language, perhaps sometimes, is thinking about the financial efficiency of government departments, perhaps when so many public sector employees are on the payroll and so on. So so there is that potential, but while at the same time allowing for government decision making to be ever more present in people's lives. So here I'm thinking of, the ease or seeming ease in which automated decision making tools can become a part of everyday life. So thinking about even the COVID tracing apps that exist now, where you can be followed around and your location can be identified through the use of your smartphone, and then you can be identified as a potential risk for having come in contact with somebody else, et cetera, and potentially many more types of administrative sanctions or actions might be taken against you if it's found that you have come in contact with someone, in terms of requiring that you self-isolate or self-quarantine and so on. And these types of advances in, we might think of it as some sort of automated decision-making, or tracking and identifying, at least, which might fall into that kind of more wide-scale type of decision that might not be a decision for directive purposes, in terms of identifying groups of populations who are risky or who need to be further investigated and so on. But the relative ease with which automated decision-making and other types of tools allow that type of expansion of state power to occur, I think is something that is quite distinct. So while automated decision-making might, of course, shrink down the public service or civil service, and represent a black and white notion of what the law says or how the law might apply in a given set of circumstances, it does at the same time allow for this proliferation of, I think, state authority in ways that we might not even recognize today, because there is no human there in a uniform saying, you have to do X or Y, or we're not going to give you A or B, and so on. So I think that is something that is quite unique about the moment that we find ourselves in, and what administrative law or anything else has to say about that is probably beyond the scope of this conversation. But I think it's something that is a really rich area for exploration in terms of future scholarship.
Yeah.
Yeah.
Well, we've created a good agenda for other people if they want to do more work in this area. I think we've flagged a whole bunch of things where there could be a lot more to think about and to work on.
Yeah.
But I see Katie on the screen, so I suspect that means that we need to wrap it up. So I'll
I
turn it
wonder
over
if
to
you
you.
have any concluding comments just before we clap off the conversation, because it's been a particularly rich and fabulous one. I've been just so excited to sit here listening to your expertise, both of you.
Well, I just want to say I was thrilled to have the chance to just talk about these ideas with anyone. That was wonderful enough, but to talk with Professor Raza was a real treat, because I admire her work and her thinking in these areas. So I had a great time. I enjoyed this very much, and I appreciate the thoughtful comments, and hope we can have more conversations like this going forward.
For sure. Likewise, I was thrilled to read your paper and to see your take on things, because I've read your work in the privacy data protection area, and so I think you bring a unique perspective to these issues, and specifically to the directive, noting how it's quite a unique instrument. And so I really enjoyed reading your paper and getting so much rich background detail as to the evolution of the directive and the ways in which it kind of corresponds with and also departs from administrative law principles. So I had an excellent time reading the paper, and I only hope that my comments are valuable as it evolves forward into its next iteration for publication.
Yeah, well, thank you so much.
Well, I think that if we were here in person, we would have a line of people a mile long standing up at the microphone to join the conversation and ask all kinds of pressing questions. I know I was making notes as you were talking, thinking about how these pesky humans can be reined in, but also, thinking through the reification of existing power structures that happens when we move to an algorithmic model. It's an important and fabulous discussion, and I'm so glad that people such as yourselves are devoting your considerable intellect to answering these questions. So we don't have this microphone today, but what we do have is comment sections below, where we invite all of the people watching this video to join in, to comment, to connect with the author and the discussant on these interesting ideas as we navigate how to build a better and more just society in the face of emerging tech. So thank you so much to both of you for joining us and for your great work. And hopefully we'll see you again in person soon.
Well, thank you.
Thank you.